to pay his check at a donut shop, and he was charged with impersonation. Diane says that her husband suffers from insanity, and her mother says he doesn't enjoy it. And this month's meeting of the Clairvoyance Club has been canceled due to unforeseen circumstances. And today in Harrison, a wine truck collided with a cheese truck, resulting in an instant fundraiser. This is about the lying and law-breaking and covering up of John Malone, Bob Magnus, and Telecommunications Incorporated. They have cost us 1,410 hours, and if you multiply each hour by $250, which is what these crooked lawyers and monopolists, antitrust get for their crimes, it comes out to $352,500 of legal labor that we have done. Malone's law-breaking, lying, and covering up. We spent $2,820.30 on print, postage, and rip-off court stenographer fees. With 38 weeks of emotional disturbance, 3 months of murdered speech, 8,042 pages, must be 23 or 4, 34 volumes of 34 volumes and 3 file drawers of law-breaking, lying, and cover-up, 88 mailings, 101 chapters, a half an hour each of TV reports, all bad. I would not care for a record like that. I would like to have my life worth more than that. So we have Malone, Magnus, and TCI in several courts. We have them in the United States District Court, Southern District of New York, Glendora versus Malone, Magnus, and TCI. They're robbing us of Channel 8 public access. We have them in the United States District Court, Southern District of New York, in a second lawsuit, Glendora versus Telecommunications Incorporated, where these defendants turned down the audio on Glendora's program. What she was reporting was not a very glamorous picture of TCI, and so they turned down the audio at 9:08 p.m. through to the end of the program at 9:30 p.m. And the great big paper, Glendora's objection to the report and recommendation of Mark D. Fox that Judge Rakoff dismissed Glendora's the case. It was this thick, and it went into Judge Rakoff, and a copy went to their lying lawyer, Ben Wiley Wiles, and a copy went to the clerk, the original, and a copy went to Judge Fox, along with this application by plaintiff appellant Glendora. Sorry about that, microphone. Appellant Glendora, for the third time that Judge Fox recused himself. And of course the affidavit for that was Glendora's objection to Judge Fox's crooked, biased, prejudiced, immature, puerile report and recommendation to dismiss her case. He's a man you cannot trust. He ought to be labeled the way cigarette packages are labeled. Do not, warning, this judge may be injurious to your health. I don't know what to do about the press. This is certainly a story for the New York Post to get rid of Judge Fox the way they got rid of Judge Duttman. And certainly the way they got Judge Barrett to stand up for people's rights. And see, we're having a problem here. So those are the copies for the newspaper. We've been reading the annual report of this crooked company. I'll show you again the pictures of John Malone and Robert Magnus, these billionaire lawbreakers. Both Malone and Magnus both Malone and Magnus, I started to say before the camera shut itself off, get $850,000 a year. Salary only, and then all the stock options. Now I'm going to read you these stats, how much money they make, what their total revenue is. That figure is in billions, okay? $6,651,000,000. Operating cash flow, $1 billion. What is it? 960, almost $2 billion. And their net earnings, they can't earn anything. They're $171 million minus net earnings. Their total assets are stockholders' equity, that's $4,550,000,000. And they have well, just go back over the figure. Total revenue is $6,851,000,000. So just remember, $7 billion. These are the people who murdered public access, core cable television operations. This was for the year of 1995. That was the year they started to murder public access and free speech. And I'm going to take this book and I'm going to annotate it. I have already annotated it, and I'm going to send it to billionaire John Malone, who makes all the little workers at TCI, little tiny incomes where they can barely subsist. And here is the fella, Brendan Clouston. Here's a picture of him. And the cable TV business brought in $5,384,000,000 total revenue. And if you look through here, they say what all their goals are through here. See, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And then their sixth goal is to murder public access, which they did. And at last is a woman in management. Can you believe that? An actual woman. And that person you just saw was Barry Marshall. And here is his signature. This is about digital TV. This is Scott Brown's boss. Scott Brown made the lousy decision and then he skipped town. This is about Prime Star. If you buy direct satellite, do not buy Prime Star because it's owned by TCI. Somewhere they put in here that TCI takes television into tomorrow. Of course, I crossed out the tomorrow and said that TCI takes television into yesterday. Here's a couple more women in the management. But you notice there are no women in the main management, and there are no women on the board of directors. Tony Coelho is not a defendant. Right there. They are a horizontal and a vertical monopoly. They are murderers of public access. They are traitors to their country and free speech. And this is what they do with their lives. Play with blocks. And get $850,000 a year for doing that. Here is a defendant, Peter M. Barton. And he's head of the Liberty Group, but Liberty for them is censorship, and here's Peter Barton's signature. That's a pretty good idea of what their spirit is. Malone. Let's see if we can find some more pictures of defendants for you. Here's Barry Diller. Remember, he was going to sell QVC to CBS, but it didn't work out, and he sold it instead to TCI, and TCI owns everything. Now here's Gary K. Bracken and Bernard W. Shotters. These are my defendants. And let me see if I can find their signatures for you. They're the financial people. Their signatures are not here way until the end. I have read half of this, folks. I read on it 15 minutes a day. Okay. Legal papers. We heard from Judge Barbara S. Jones on the censorship TCI case. She has set a conference for September the 5th at 2 p.m. Thursday. That's the day I edit, so I've got to call up and see if they will not please change that. The last paper that went to Barbara Jones, oh yeah, they took off another channel and put on another channel. They're adding a channel, but of course they're not adding public access. I had long talks with the city manager of Rye, why don't you sue TCI, and with the supervisor of Eastchester, why don't you sue TCI. Written on Saturday to the Honorable Barbara S. Jones, United States District Judge, Southern District of New York, Glendora versus Telecommunications, Bob Magnus, John C. Malone, Fred A. Vieira, Brendan M. Clouston, Brendan R. Clouston, J. C. Sparkman, Stephen M. Brett, Peter R. Barton, Larry E. Romrell, Barry P. Marshall, Gary K. Bracken, Bernard W. Shotters, Robert W. N. Thompson, Jerome H. Kern, Ted Turner, Richard Wadman, Miles Rich, Brenda Cherry, tape operator, and any other Jane or John Doe on duty April the 30th, 1996 at 4 p.m. to midnight at 609 Center Street, Mamaroneck, New York, and Wendy Sirkin. Defendants. Glendora reiterates and incorporates by reference each and every allegation in her complaint, in her letters and telephone calls to defendants, in her demand for home addresses pursuant to Local Rule 2, in her 8 discovery demands, in her motion for default judgment, in her motion to compel and sanction for defiance of said Rule 2, in her letter about a discovery dispute of August the 11th, 96, in her application to strike Wiles' letter of August 9th, in her opposition to Wiles' letter number 2, to strike all 3 letters that Wiles has written because he is not the counsel of record. Sent to this court overnight express mail and to Glendora by regular mail. Wiles sends a letter to the judge by express mail and sends it to me by snail mail. Wiley Wiles is not the counsel of record. Proof demanded in Glendora's refutation of his letters 1 and 2 of August 12th and August 14th has not been produced. The counsel of record is Baker and Botts, as per the proof Glendora sent this court, both on the acknowledge of service of complaint and summons and on the docket. The party crashed of Wiley Wiles must be struck from the record. Not another paper must be allowed to this court without proof that he represents each and every defendant, and to what extent. This interloper writes letters and not letter briefs, which are to be double-spaced in 2 pages instead of grown-up legal papers. You want to know why? So he does not have to declare under penalty of perjury. Also, he does not have to declare that he's fully familiar with the facts and circumstances. He is not. A, he is not the defendant's attorney. B, he was not there when the censorship happened. C, there has been no discovery by Baker and Botts. The last paragraph of Judge Jones, while this action is pending, it is the responsibility of the pro se plaintiff immediately to inform Judge Jones directly of any changes of address. I inform you of one right now. Pro se plaintiff informs you that the correct address of the attorney on this case follows. It is Baker and Botts, 599 Lexington Avenue, 29th floor. Ben Wiles is already poisoned this case and must be sanctioned, even though he is the attorney on this case. 96 Civ 4270 is not the attorney by causing the court to refer to Glendora Buell, who was not a party to the action. The plaintiff is Glendora. The express overnight was sent to Glendora Buell. Andrew Mohan called and asked for Glendora Buell, and Wiley Wiles must be sanctioned for the same. He must further be sanctioned for penetrating this court 3 times illegally. Defendants have not filed a Rule 9 statement, general rules. A Chat with Glendora is on 11 cable TV systems, and then I list them. You know them all: Time Warner, Manhattan, Cablevision Long Island, Cablevision East Hampton, TKR Rockland, Northern New Jersey, Continental, Tarrytown to Ossining to Peekskill, Cablevision Harrison, Port Chester, Cablevision Yonkers, Cablevision Yorktown, Cablevision Cross River, White Plains Public Access, TCI New Rochelle, Pelham. You can see it Thursdays 8:30 a.m. Channel 16, uptown, downtown, and in the ladies' chamber. That's the lady, Barbara S. Jones. Defendants counsel Baker and Botts have not answered anything, not in writing, not by telephone. A deeper default Glendora has never known. Plaintiffs amici curiae in Glendora versus Cablevision, which won in the Second Circuit and in the Charles L. Bryant Court, had the following article in the New York Law Journal yesterday about the Denver case. And I will show you a picture of my amici curiae, Robert Perry and Brian Grafman, of whom you have heard so much. Professor Perry is the one on your left, and Brian Grafman is the one on your right. And they had this long, long article in the New York Law Journal about the Denver case and about public access is a public forum. Any fool can see that. Yesterday, Franklin telephoned John Malone to find out what happened at the annual meeting the day before. Glendora had tried to go but could not raise the money for travel. Franklin was referred to investor relations. He was told there was only one disruptive shareholder. He wanted cash dividends. The cash goes into the pockets of Magnus, Malone, Vieira, Clouston et al., $850,000 annual salary and $4 billion in stock options. The meeting lasted from 10 a.m. to 12 p.m. There were 200 people present. When can I get a copy of the minutes? Asked Franklin. Said the investor relations, I will have to ask the legal department. Call back this afternoon. The afternoon answer was, you'll have to put it in writing. You'll have to say why you want the minutes. Said we, a shareholder does not have to say why he wants the minutes of the annual meeting. All right, then just give evidence that you are a shareholder. This is the type of lying and cover-up these defendants stoop to. This court must be aware of the misrepresentation by these defendants pursuant to Rule 11 sanctions. Glendora refutes every sentence of Wiles' letter number 3 to Judge Jones. And then I go through and refute it all. And this turns out to be 17 pages long. He is a party crasher. He is a liar. I'm talking about Ben Wiles. And Ann Salisbury, he puts Ann Salisbury at the letter, but Ann Salisbury doesn't sign the letter. So if you were a judge, what would you do about that? Now we'll go backwards here and see what other epistles went out. On August the 8th, 16th, 1996, Glendora writes an application by plaintiff to admit 3 persons as amici curiae. That went to Judge Rakoff. Public access channels constructed a designated public forum of unlimited character. Concurring opinion at Part 3B. In joining the striking of that portion of the statute, Justice Stevens specifically stated that it was not necessary to characterize public access channels as a public forum. Justices Breyer and Souter, in striking the same provision, also declined to address the public forum doctrine and did not need to. Justice O'Connor, although upholding the provision at issue there as constitutional, did not discount the public forum doctrine as applicable, and in fact performed what seems to be a First Amendment analysis that would be consistent with applicability of the public forum doctrine. Only Justice Thomas, joined by Chief Justice Rehnquist and Justice Scalia, rejected the notion of the public access channels constituting a public forum. Thank you for your consideration, Brian D. Grafman. Now, there are only 2 more pages. Well, there's actually 1. Glendora has shown this court in her pages 1 to 137 that summary judgment cannot be granted, and pleads defendant's motion for same in their favor be denied in its entirety and plaintiff's complaint not be dismissed. Further, plaintiff pleads on the grounds of res judicata, law of the case, that defendant's motion for an order dismissing her complaint for lack of personal jurisdiction as to defendants Hosted and Air, Ritter, Hawthorne, DeLorme, Schley, and Guthrie also be denied. Plaintiff asks this court for an order granting her motion request and her motion of April 27, 1996. Resubmitted June the 3rd. In its entirety, pursuant to Rule 37A and B, Federal Rules of Civil Procedure. Plaintiff asks this court to open discovery immediately with fact discovery and deposition by Glendora done by August 31st, 1994. 6 rather. Expert reports done by September 30th. Rebuttals done by October 31st. Expert depositions done by November 30th, pretrial conferences done by December 15, 1996. Plaintiff pleads for $298 million compensatory and punitive damages, make goods of all programs Saturday or Sunday afternoons by October 1st, 1996, and any further and different relief that is just and proper. Dated White Plains, New York, July the 11th, 1996. Yours in truth, Glendora. Chat with Glendora. 66 hours this took, and it cost $120.83. to print it and post it. 45 seconds we're going to use for jokes. The speaker at the banquet says I only have 2 minutes left of my speech. He says I'm going to stop now though because I need that 2 minutes for the applause. Did you hear the headline on the TV news that the Coast Guard reports that 2 ships were collided off of the coast of Florida? One ship was carrying a load of red paint. The other ship was carrying a load of purple paint, and at last report, the passengers and crew of both ships were marooned. Crossword puzzle addict Claire Putter has inserted a new clause in her will. When she dies, she wants to be buried 6 down and 3 across. A White Plains resident was hauled into court for failing to pay his check at a donut shop, and he was charged with impersonation. Diane says that her husband suffers from insanity, and her mother says he doesn't suffer from it, dear, he enjoys it. And this month's meeting of the Clairvoyance Club has been canceled due to unforeseen circumstances. And today in Harrison, a wine truck collided with a cheese truck, resulting in an instant fundraiser. This is about the lying and law-breaking and covering up of John Malone, Bob Magnus, and Telecommunications Incorporated. They have cost us 1,410 hours, and if you multiply each hour by $250, which is what these crooked lawyers and monopolists, antitrust get for their crimes, it comes out to $352,500 of legal labor that we have done. Malone's live law-breaking, lying, and covering up. We spent $2,820.30 on print, postage, and rip-off court stenographer fees. With 38 weeks of emotional disturbance, 3 months of murdered speech, 8,042 pages, 23 or 4, just a second. 34 volumes of 34 volumes and 3 file drawers of law-breaking, lying, and cover-up, 88 mailings, 101 chapters, a half an hour each of TV reports, all bad. I would not care for a record like that. I would like to have my life worth more than that. So we have Malone, Magnus, and TCI in several courts. We have them in the United States District Court, Southern District of New York, Glendora versus Malone, Magnus, and TCI for robbing us of Channel 8 public access. We have them in the United States District Court, Southern District of New York, and the second lawsuit, Glendora versus Telecommunications Incorporated, where these defendants turned down the audio on Glendora's program. What she was reporting was not a very glamorous picture of TCI. And so they turned down the audio at 9:08 p.m. through to the end of the program at 9:30 p.m. And the great big paper, Glendora's objection to the report and recommendation of Mark D. Fox that Judge Raycroft dismissed Glendora's case. It was this thick, and it went into Judge Raycroft, and a copy went to their lying lawyer, Ben Wiley Wiles, and a copy went to the clerk, the original, and a copy went to Judge Fox, along with this application by plaintiff appellant Glendora. Sorry about that, microphone. Appellant Glendora, for the third time that Judge Fox recused himself. And of course the affidavit for that was Glendora's objection to Judge Fox's crooked, biased, prejudiced, immature, puerile report and recommendation to dismiss her case. He's a man you cannot trust. He ought to be labeled the way cigarette packages are labeled. Do not. Warning, this judge may be injurious to your health. I don't know what to do about the press. This is certainly a story for the New York Post to get rid of Judge Fox the way they got rid of Judge Duttman. And certainly the way they got Judge Bear to stand up for people's rights. And see, we're having a problem here. So those are the copies for the newspaper. We've been reading the annual report of this crooked company. I'll show you again the pictures of John Malone and Robert Magnus, these billionaire lawbreakers. Both Malone and Magnus both Malone and Magnus, I started to say before the camera shut itself off, get $850,000 a year.
salary only, and then all the stock options. Now I'm going to read you these stats, how much money they make, what their total revenue is. That figure is in billions, okay? 6,651,000,000. Operating cash flow, 1 billion. What is it? 960, almost 2 billion. And their net earnings, they can't earn anything. They're $171 million minus net earnings. Their total assets are stockholders' equity, that's $4,550,000,000. And they have well, just go back over the figure. Total revenue is $6,851,000,000. So just remember, 7 billion. These are the people who murdered public access, core cable television operations. This was for the year of 1995. That was the year they started to murder public access and free speech. And I'm going to take this book and I'm going to annotate it. I have already annotated it, and I'm going to send it to billionaire John Malone, who makes all the little workers at TCI, little tiny incomes where they can barely subsist. And here is the fella, Brendan Clouston. Here's a picture of him. And the cable TV business brought in $5,384,000,000 total revenue. And if you look through here, they say what all their goals are through here. See, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And then their sixth goal is to murder public access, which they did. And at last is a woman in management. Can you believe that? An actual woman. And that person you just saw was Barry Marshall. And here is his signature. This is about digital TV. This is Scott Brown's boss. Scott Brown made the lousy decision and then he skipped town. This is about Prime Star. If you buy direct satellite, do not buy Prime Star because it's owned by TCI. Somewhere they put in here that TCI takes television into tomorrow. Of course, I crossed out the tomorrow and said that TCI takes television into yesterday. Here's a couple more women in the management. But you notice there are no women in the main management, and there are no women on the board of directors. Tony Coelho is not a defendant. Right there. They are a horizontal and a vertical monopoly. They are murderers of public access. They are traitors to their country and free speech. And this is what they do with their lives. Play with blocks. And get $850,000 a year for doing that. Here is a defendant, Peter M. Barton. And he's head of the Liberty Group, but Liberty for them is censorship, and here's Peter Barton's signature. That's a pretty good idea of what their spirit is. Malone. Let's see if we can find some more pictures of defendants for you. Here's Barry Diller. Remember, he was going to sell QVC to CBS, but it didn't work out, and he sold it instead to TCI, and TCI owns everything. Now, here's Gary K. Bracken and Bernard W. Schotters. These are my defendants. And let me see if I can find their signatures for you. They're the financial people. Their signatures are not here way until the end. I have read half of this, folks. I read on it 15 minutes a day. Okay. Legal papers. We heard from Judge Barbara S. Jones on the censorship TCI case. She has set a conference for September the 5th at 2 p.m. Thursday. That's the day I edit, so I've got to call up and see if they will not please change that. The last paper that went to Barbara Jones oh yeah, they took off another channel and put on another channel. They're adding a channel, but of course they're not adding public access. I had long talks with the city manager of Rye, why don't you sue TCI, and with the supervisor of Eastchester, why don't you sue TCI. Written on Saturday to the Honorable Barbara S. Jones, United States District Judge, Southern District of New York, Glendora versus Telecommunications, Bob Magnus, John C. Malone, Fred A. Vieira, Brendan M. Clouston, Brendan R. Clouston, J. C. Sparkman, Stephen M. Brett, Peter R. Barton, Larry E. Romrell, Barry P. Marshall, Gary K. Bracken, Bernard W. Shotters, Robert N. Thompson, Jerome H. Kern, Ted Turner, Richard Wadman, Miles Rich, Brenda Cherry, tape operator, and any other Jane or John Doe on duty April the 30th, 1996 at 4 p.m. to midnight at 609 Center Street, Mamaroneck, New York, and Wendy Sirkin. Defendants. Glendora reiterates and incorporates by reference each and every allegation in her complaint, in her letters and telephone calls to defendants, in her demand for home addresses pursuant to Local Rule 2, in her 8 discovery demands, in her motion for default judgment, in her motion to compel and sanction for defiance of said Rule 2, in her letter about a discovery dispute of August the 11th, 96, in her application to strike Wiles' letter of August 9th, in her opposition to Wiles' letter number 2, to strike all 3 letters that Wiles has written because he is not the counsel of record. Sent to this court overnight express mail and to Glendora by regular mail. Wiles sends a letter to the judge by express mail and sends it to me by snail mail. Wiley Wiles is not the counsel of record. Proof demanded in Glendora's refutation of his letters 1 and 2 of August 12th and August 14th has not been produced. The counsel of record is Baker and Botts, as per the proof Glendora sent this court, both on the acknowledge of service of complaint and summons and on the docket. The party crashed of Wiley Wiles must be struck from the record. Not another paper must be allowed to this court without proof that he represents each and every defendant, and to what extent. This interloper writes letters and not letter briefs, which are to be double-spaced in 2 pages instead of grown-up legal papers. You want to know why? So he does not have to declare under penalty of perjury. Also, he does not have to declare that he's fully familiar with the facts and circumstances. He is not. A, he is not the defendant's attorney. B, he was not there when the censorship happened. C, there has been no discovery by Baker and Botts. The last paragraph of Judge Jones, while this action is pending, it is the responsibility of the pro se plaintiff immediately to inform Judge Jones directly of any changes of address. I inform you of one right now. Pro se plaintiff informs you that the correct address of the attorney on this case follows. It is Baker and Botts, 599 Lexington Avenue, 29th floor. Ben Wiles has already poisoned this case and must be sanctioned, even though he is the attorney on this case. 96 Civ 4270 is not the attorney, by causing the court to refer to Glendora Buell, who is not a party to the action. The plaintiff is Glendora. The express overnight was sent to Glendora Buell. Andrew Mohan called and asked for Glendora Buell, and Wiley Wiles must be sanctioned for the same. He must further be sanctioned for penetrating this court 3 times illegally. Defendants have not filed a Rule 9 statement, general rules. A Chat with Glendora is on 11 cable TV systems, and then I list them. You know them all: Time Warner, Manhattan, Cablevision Long Island, Cablevision East Hampton, TKR Rockland, Northern New Jersey, Continental, Tarrytown to Ossining to Peekskill, Cablevision Harrison, Port Chester, Cablevision Yonkers, Cablevision Yorktown, Cablevision Cross River, White Plains Public Access, TCI New Rochelle, Pelham. You can see it Thursdays 8:30 a.m. Channel 16, uptown, downtown, and in the ladies' chamber. That's the lady, Barbara S. Jones. Defendants counsel Baker and Botts have not answered anything, not in writing, not by telephone. A deeper default Glendora has never known. Plaintiffs amici curiae in Glendora versus Cablevision, which won in the Second Circuit and in the Charles L. Bryant Court, had the following article in the New York Law Journal yesterday about the Denver case. And I will show you a picture of my amici curiae, Robert Perry and Brian Grafman, of whom you have heard so much. Professor Perry is the one on your left, and Brian Grafman is the one on your right. And they had this long, long article in the New York Law Journal about the Denver case and about public access is a public forum. Any fool can see that. Yesterday, Franklin telephoned John Malone to find out what happened at the annual meeting the day before. Glendora had tried to go but could not raise the money for travel. Franklin was referred to investor relations. He was told there was only one disruptive shareholder. He wanted cash dividends. The cash goes into the pockets of Magnus, Malone, Vieira, Clouston et al., $850,000 annual salary and $4 billion in stock options. The meeting lasted from 10 a.m. to 12 p.m. There were 200 people present. When can I get a copy of the minutes? Asked Franklin. Said the investor relations, I will have to ask the legal department. Call back this afternoon. The afternoon answer was, you'll have to put it in writing. You'll have to say why you want the minutes. Said we, a shareholder does not have to say why he wants the minutes of the annual meeting. All right, then just give evidence that you are a shareholder. This is the type of lying and cover-up these defendants stoop to. This court must be aware of the misrepresentation by these defendants pursuant to Rule 11 sanctions. Glendora refutes every sentence of Wiles' letter number 3 to Judge Jones. And then I go through and refute it all. And this turns out to be 17 pages long. He is a party crasher. He is a liar. I'm talking about Ben Wiles. And Ann Salisbury, he puts Ann Salisbury at the letter, but Ann Salisbury doesn't sign the letter. So if you were a judge, what would you do about that? Now we'll go backwards here and see what other epistles went out. On August the 8th, 16th, 1996, Glendora writes an application by plaintiff to admit 3 persons as amici curiae. That went to Judge Rakoff. You knew that it was canceled, right? We had a meeting with Judge Jones scheduled for last Friday at 3:45 p.m. and it was canceled. Now it's set for September 5th at 2 p.m. Okay, seeing what other legal papers there were this week. 8/14/96 Wednesday, we're up to the point where we left off the reports for last week. Let me show you who the lawyers on record are. It's Baker and Botts, 599 Lexington Avenue, 29th floor, New York, New York, 1022, and that signature is Michael C. Lippert. Baker and Botts, Defendants Counsel. Just as plain as anything, isn't it? July 18th, 1996. We will read you some more of this. The Grafe and Perry article is going to be in the New York Law Journal in Part 2 this Friday. Wiles did send a third letter, even though he is not the counsel within and is crashing the party. He did send it express mail, and it was received by Glendora next day, August 16th at 6 p.m. About letter number 2, which was sent to Glendora snail mail and sent to the court express mail, Judge Jones has a rule that the same method of delivery must be used to the court as to the other side. Mr. Wiles must be sanctioned even though he is not the attorney on this case but is an interloper. We are not the attorneys for the individuals and corporations named as defendants in the above referenced matter. Wiles, Cohen, Dox, Koenig are not the attorneys. Where is the proof? Where is the affidavit from each individual Glendora named as a defendant that the intruder Wiles is their attorney? Where is the affidavit from the corporation? These must be produced but cannot be because Ben Wiles is a phony. How did he understand? How did he get the word? Eavesdropping? He is not the lawyer on Glendora versus Telecommunications Incorporated. He has no authority to request anything from this court. He is not representing Glendora's defendants. Salisbury of Baker Botts did not sign this letter of August 15. Judge Jones does not need Ben Wiles nor any other lawyer, nor on this case, 96 Civ 4270, to tell her she will schedule a conference as soon after September 30 she can. No, we advise the court in any August 8th letter. There was no signature by Salisbury of said letter, and Wiles is not the lawyer on this case. Anyway, Glendora's case cannot be dismissed. And here is the decision order, January the 11th, 1995, of Judge Van Grafelen. Judge Bryan's decision was vacated and remanded, and he's never got over that. And Wiles is not the attorney on Glendora versus Telecommunications. The court does not need Wiles' advice. He is not the lawyer on the case. Wiles should not be writing this court. He is an interloper. Even if the intent were to schedule a conference, it could be stated in one sentence, we want a conference if we were the attorney of record. Ben Wiles has to go into a song and dance about dismiss and disguise his real intent to poison the court before Glendora even gets to the court. This is improper. Wiles must be sanctioned pursuant to Rule 11, Federal Rules of Civil Procedure. Wiles has already said in the August 15th letter what was said in the August 9th letter, and he had no right to write either, nor the August 8th letter. He is a charlatan. Phone call with our court stenographer, Vera Monaco. Okay, Wiles has already said in the August 15th letter what was said in the August 9th letter, and we had no right, and he had no right to write either, nor the August 8th letter. He is a charlatan. The counsel is Baker and Botts, and Baker Botts never signed any of these letters. Sanctions are in order, and over again. As usual, Wiles is making a fool of himself and trying to make a fool of the court. Wiles is not the attorney of record. Salisbury did not sign the August 8th letter. Even if he were the attorney of record, he never mentioned the above in his August 8th letter. He had no right to contact Glendora. Well, he said that he asked Glendora for an extension and Glendora wouldn't grant it, and that he said this in the other letter, but he didn't say it in the other letter. Baker Botts did not ask Glendora pursuant to Rule 6 for an extension, and that letter went out on Saturday, the 17th. And I don't serve him on Wiles, I serve him on Baker and Botts because Wiles is not the attorney of record. We're going to have 3 jokes, and then we're going to close. And this is what happened on the law breaking of Malone, Magnus, and TCI from August the 15th, Thursday, to today, August the 21st, Wednesday. I have to videotape early because tomorrow we go to small claims court for those crooked, another set of crooked cable TV operators, Cablevision. They went and spent the money for the subpoena money. They didn't have to come to trial because it was stayed, and they went out and spent the money. They converted the money to their own use. Here they are, billionaires. Okay. Our company just bought a new conference table. And they went out and spent the money. They
one party in total and complete control in this county since its inception almost 100 years ago, and that's the Republican Party, and that's all well and good, but I think if you take the time to examine what our forefathers intended when they created this wonderful country of ours, was supposed to be a two-party system, and I think any one party that remains in total and complete control anywhere for any length of time causes problems for the public at large. That's true of the Democrats when they were in control of the city of New York. It's certainly true of the Republicans in Nassau County. So I'm not riding on a white charger and suggesting that the Republican Party is an evil party. No, it isn't. It just becomes very complacent and very arrogant, and when that happens with any party that's in complete control, you suddenly find your taxes go up. Administrations don't necessarily respond to the people the way they should. So if there were one message I would give to the Nassau County taxpayers and residents, it would be, examine the records of the individuals who run for office, and don't have just a knee-jerk reaction and vote the straight party line. Try to pick out people that you think are best going to represent you, irrespective of what party they might be in. I'm somewhat unique since I'm a Democrat in what would be certainly considered an overwhelming Republican town. The town of Oyster Bay, in terms of registration, is overwhelmingly Republican. So I've been very fortunate in that the residents of this town have taken the time to examine my record and those of my opponents, and have managed to return me to office for the last 3 terms. And I appreciate that. I've managed to reduce the town real property tax rate in numbers that no one ever thought I could. It was historic, some of the tax cuts that I inaugurated in the town of Oyster Bay. And that's what I think the two-party system is all about. When you get someone in from the opposing party, you will see changes occur, and generally those changes are for the good. They benefit the public, and I think my administration has proven that, and it's been proven elsewhere in this country.
Well, Mr. Uvoli, I want to thank you that you came right out of your office to speak to the people. We appreciate it.
My pleasure.
I want to get a picture of your dad. Is he behind me?
Yeah, he's right here, 85 years old. And
there.
As healthy as anyone can be.
Hello, Dad, Anthony Uvoli.
Mr. Rabbit, just say hello. You want me to give you a big smile? Yeah, give a little wave. I'll give you one for nothing.
And this, folks, is Chuck Johnson. Chuck, how are you today?
Oh, fine.
Yeah.
Yes, I'm the deputy, and it's a pleasure to see you today.
Yeah, I'm glad you came out.
Thank you very much.
Okay, fellas, we thank you so much.
Thank you.
Bye-bye. I should have mentioned Franklin Buell. He was there, too. Good morning, folks. This is a chat with Glendora, and I'm glad you had a chance to meet Louis Uvoli, who is the supervisor of the town of Oyster Bay. And Mr. Uvoli is going to run for county executive, I believe, for the county of Nassau. And Mr. Uvoli is a Democrat. There is much to report to you on the law-breaking of Charles Dolan, John Tata, William Quinn, et al. Of Cablevision Systems Corporation. But before that, we have to have our jokes. Do you have a good preacher? Sid was asked. Sid says, yes, at the end of every sermon there's a great awakening. And Andy said, Mom, did you say the name of the preacher is Reverend or never end. And Paul said, what does procrastination mean? And Bobby said, it's something that Presbyterians believe in, I guess. And Columbus set sail in the wrong direction from Spain, looking for the India, and he landed in the Bahamas, and he decided that he had discovered America. And if he were alive today, he'd be working for the United States Post Office. A little girl asked Diane, says, "Mummy, do all fairy tales begin with once upon a time?" And Mummy says, "No, dear. Some of them begin with, if I'm elected." And Ed walked up to the post office window and he said to the clerk, "I'd like $50 worth of stamps." And the clerk said, "Well, what denomination?" And Ed said, "Baptist." Bob said he got a COD package, and his son said, "What does COD mean, Daddy?" And Daddy said, "Crushed on delivery." Now, I'm going to give you a very brief and fast synopsis. In 1993, I was on cable television, Channel 25, 10 p.m., right where I am today, on the so-called Cablevision of Long Island, Woodbury system. That includes all of Nassau, some of Islip, Huntington, and Babylon. And I was telling the consumers of Nassau County that the Department of Consumer Affairs was allowing Scott Lord to operate a home improvement business, an underground lawn sprinkling business, is underground and how, without a Consumer Affairs license. And that Scott, the Department of Consumer Affairs, Mr. James Picken, who is the commissioner, who is also the chairman of the Republican Town Club, town of Oyster Bay, was not protecting you consumers. Under his full knowledge, Scott Lord was operating a consumer affairs business with no home improvement license. The other contractors have to pay $1,000 practically to get a consumer affairs license. And that I had videotape proof of this, and that this was being done under the full knowledge of the Department of Consumer Affairs, not protecting you consumers. Because across the street, Old Country Road, in the clerk's office, you go over there and you'll find almost 100 judgments against Scott Lord, Atlantis Lawn Sprinkler, now operating as Forever Green. Every year the name of the company changes, every half year the lawyer changes, and every year the address changes. And also this was done under the full knowledge of Thomas Galata, the county executive. Mr. Galata is very nice and very likable, and he and I had exchanged maybe 12 letters about this matter, but nothing was ever done about it. And my reports got more and more excoriating. Around about November of 1993, Cablevision had in its custody at Hicksville 4 of my programs reporting on the dereliction of the Department of Consumer Affairs of Nassau County. I believe, upon information and belief, that somebody saw these tapes and somebody said, "Do not let those reports get on TV." At which point, on November the 12th, Armistice Day, day after Armistice Day, Veterans Day, I received a telephone call, and it's all documented, and it's all on audio tape, saying that my program would not be seen anymore on Cablevision Channel 25, 10 p.m. And the reason given that this was no place for a person to discuss his personal disputes with another person. So this was done on content and content alone. Cablevision, Dolan, Tata, Quinn et al., in their arrogance and their ignorance, cable TV operator arrogance, monopoly, and their ignorance of the United States laws, and hello kitty, this is our new kitty that we rescued. Cute, isn't that the cutest little thing? in their arrogance and their ignorance, broke both a state law and a federal law. Let me tell you quickly what those laws are. They both say the same thing, but in different wording, that no cable operator shall exercise editorial control over public use of channel. This is public channel. Don't get it confused with Channel 13. This is public access channel. These channels belong to you. For the moment, temporarily, Cablevision has to be administering them. But these channels are yours, and they are strictly governmental functions. So what did they do? They violated 829.3 New York Executive Law, Article 28. They violated Title 47 of the United States Code 531E, the law that I just told you. So I sued them, and I sued them for $31 million. And this was in December 6, 1993, and I won. I sued them in the New York Supreme Court, County of Westchester. Donald N. Silverman said plaintiff has a statutory right to have her program on TV, and it must be returned to TV. I was off the TV for practically a year. I was damaged. And so they did return, Cablevision did return the program to TV on September 1994. This lawsuit made huge headlines in the New York Law Journal, the New York Times, and in a Newsday. It was certainly a case of a little person standing up to monopolists and a little person winning. Now, I got these people. It's a long story as to what happened between then and what I'm going to tell you about now. I got these people to the United States District Court, Southern District of New York, White Plains Branch, ready for trial. They were coming to trial on March the 4th, Monday. On February the 28th, Wednesday, 3 business days before, Judge Bryant, United States District Judge, stayed the trial. Franklin had served on all of these people. It would be on James Dolan, and on John Tata, and on William Quinn and Joseph Aznara, who is the general manager of the cable vision systems in Long Island. They were all subpoenaed to appear at trial and testify. They were going to be grilled in front of a jury. Judge Bryant stayed that trial. Franklin had given each of these people $40, that's the federal rule, for when you go to court. A day, $40 a day, plus $30 travel expense from Woodbury up to White Plains. When the trial was stayed, these people, these billionaires, instead of returning the money, $70 apiece, 5 of them, $350 total, converted the funds to their own purposes. They deposited Franklin's $350 in the bank under the compensation fund. Can you imagine? Millionaires, billionaires, monopolists, Cablevision, the Dolans, Tata, Quinn et al., Aznara being that cheap. Well, they were. Franklin's checks came back canceled, cashed. And so this was back in February, March, and April of '96. So Franklin sued them in small claims court in Yonkers, because the Yonkers court is the fastest court we have in Westchester. White Plains is unbelievably slow. Unbelievably slow. You'll be a year and a half in White Plains City Court trying to resolve a small claim matter. And so we went to Yonkers, and the trial was last week, August the 22nd. And it was before Thomas Dickerson, city judge of the city court of the city of Yonkers. And can you believe this? Cablevision had a lawyer, Satterley, Stevens, Burke and Burke, 230 Park Avenue, come all the way up from Manhattan to Yonkers to defend this $350 that they stole. Judge Dickerson said, "Are you going to pay it?" And the lawyer said, "No." Just think how much it cost screwball Cablevision to have a lawyer come up to Yonkers from Manhattan. And he was there from 2 to 3 p.m. Now these people get $250 an hour just in their office to sit down and write a simple legal paper that you and I could write. But just think what they get for all the travel, and just what they think they get for appearing in court. Now, I am going to read you, what happened at the trial. The lawyer maintained that these subpoenas had not been quashed, but that is not what had happened in the Bryant court. What had happened in the Bryant court was that Judge Bryant said they were moot, and that Cablevision lawyer had not served upon the court an affidavit of service. That's what happened in court, and this lawyer, that's what a lawyer is, a liar for hire, was trying to tell Judge Dickinson. And I shook my head, and I told Judge Dickinson what did happen. We could have lost the case at that point if I hadn't shook my head. My head is loose, so it shakes quite easily. And so Judge Dickinson said to the Cablevision lawyer, David Light, Satterley, Stevens, Burke & Burke, a bunch of crooks, you get a letter in. And then he told Franklin to reply. And it would have stopped there if I hadn't said, how soon does Mr. Light get the letter in? And Mr. Light says, I'll do it this afternoon when I get back to the office. The letter didn't go out that afternoon. It went out on Friday, and it was written on Friday. But we came home, and I got up around 4 a.m. Friday morning, August 23rd, and I started writing down the things that should have been said at that trial. And I'm going to read you that. It's in longhand, and I want you people to understand that you can submit papers to the court. You do not have to have a lawyer. In fact, you're a lot better off without a lawyer. And it is written in longhand, as long as it's black on white, 8.5 by 11, and as long as it's legible. And I have done this in all courts. The United States Supreme Court, in the United States Court of Appeals, Second Circuit, and then in the United States District Court, in the New York Supreme Court, and all other courts, and now here in Small Claims Court. And this is Small Claims number 6532 of 96, Post-Trial Memorandum by Franklin F. Buell. Small Claims Part. Point 1, it would not be a case of withdrawing the subpoenas. The Cablevision lawyer Robert Callaghy, Satterley, Stevens, Burke & Burke was right there in the courtroom when Judge Bryant stayed the trial, so the defendants were informed and knew fully well that they were not to be paid $40 each for the day to come to trial, plus $30 travel expense, Long Island to White Plains. Withdrawing the subpoenas is not the issue. Defendants knowingly and deceitfully and dishonestly deposited plaintiffs' money in their bank account, and those are the names you see on the screen. Point 2, what they did is nothing but robbery, and this court no way can excuse this. Stealing my money, that's Franklin Buell's money, is not a new low for these millionaires. The very week that Cablevision bought Madison Square Garden, the Knicks and the Rangers, for $1.1 billion, they refused to pay Glendora her victory cost of $1,000 in Westchester Supreme Court. This was the spring of 1995. Glendora beat them in the Judge Silverman court. Defendants took her program off TV in Long Island because she was reporting the failure of Nassau officials to protect consumers from home improvement contractor ripoffs. Defendants Dolan, Tata, Quinn et al. Violated Title 47 United States Code 531E and New York State Executive Law Article 28, 829.3, and New York Code Rules and Regulations 595.1. Quote, no cable operator shall exercise editorial control over public use of channel. Judge Silverman ruled that plaintiff Glendora had a statutory right to be on TV and her program must be returned to TV, and it was. This is what the trial was about. Damages for recklessly violating Glendora's federal rights, both statutory and constitutional. Judge Bryant had ruled Glendora was entitled to compensatory damages. Defendants Dolan, Tata, Quinn et al. Knew the trial was stayed. This happened February the 28th. Before we were to pick our jury, March the 4th, 1996. With full knowledge of same, defendants stole the 5 checks for $70 each, witness and travel money, when they knew full well they did not have to travel and they did not have to witness. Page 4, it was and is unjust enrichment. It was illegal conversion of funds to their own use. It was and is thievery. This court cannot allow such an evil. A third nadir of these defendants is that they ordered an audio tape produced by Glendora, and Judge Bryant told them at their expense. Glendora did the work and produced the invoice and showed that the cost from an outside audio dubbing house was $95. Judge Bryant ordered Robert Callaghy 5 times to pay the $95, and he never has, after telling Judge Bryant, "I will." This is how unbelievably cheap these millionaires are, absconding with the $350 subpoena money when they didn't earn it either in witness fee nor travel is just a third in a series of skinflint maneuvers by these millionaire Park Avenue law firm and cable TV operator cheapskates. How can this court tolerate this instant ripoff placed before it? It is against society in America to take somebody's money when you didn't work for it and when you didn't lay out any expenses. It is not right that Cablevision should be getting interest on this $350 that they do not own, and that Franklin F. Buell should be losing interest on the $350 he does own. Note that these checks were deposited to the Cablevision Compensation Fund. They got compensated for work and travel that they did not perform. This is unjust compensation, unjust enrichment. Have they no pride whatsoever as Americans? Those names that you see on the screen. $350 plus 9% interest statutory constitutes a Pyrrhic victory at the most. Satterley must at least get this for appearing in Yonkers City Court Small Claims on August the 22nd, 1996, Tuesday, 2 to 3 p.m., plus travel time to and from Manhattan. Add to this the charge for the letter that Judge Dickinson ordered David Light to write. This was on August the 22nd, 96, Tuesday, 2:55 p.m. Probably a couple of hours, probably $500. The minutes that David Light so blithely mentioned at that 8/22 trial, I paid for. In 2 years, 8 months of litigation bringing Cablevision lawbreakers to justice, Satterley, Dolan, et al. Never paid a penny for minutes. We bought all the minutes, yet Light does not tell you when he says, "I have the minutes." Cablevision, Satterley, and David Light, L-E-I-T, in addition to stealing money, are stealing our time at $250 per hour, which Westchester lawyers in their antitrust get. They have cost us 50 hours times $250 equal $12,500 in legal labor. Further, they are wasting scant judicial resources. Small Claims Yonkers is a very busy court and a hard-working court. Judge Dickinson is to be commended for starting his court at 2 p.m. on Punto. We were very impressed by that. The idea of having a trial immediately after conference to settle fails, and in the same anteroom is a smart, efficient, and effective way. It is not right that $2.5 billion Cablevision, this company has assets of $2.5 billion. Park Avenue, Satterley, Stevens, Burke & Burke law firm, and David Light don't appreciate the spirit of small claims. Judge Dickinson was right to deny so speedily David Light's first motion. It was not substantive law. Franklin was there for substantial justice. Defendants have no meritorious defense for what they did and never will have. UCCA, that's the Unified City Court Act. Section 1804. Small claimants are not required to follow CPLR, civil practice laws and rules. You're not required to follow that. This is statutory law. This is substantive law. CPLR is statutory law. This is substantive law based on common law, small claims. You don't have to follow statutory law. That is not the purpose of the Small Claims Act, to cause inconvenience, increased costs, and prolonged proceedings. In a conflict between the CPLR, Civil Practice Laws and Rules of New York State, and the Unified City Court Act, the Unified City Court Act shall control. Landy versus Clark Disposal Incorporated, 1979, 100 miscellaneous, second, 1023, 420, New York State second, New York Supplement, second, 547. Franklin objects to Mr. Light giving a cite, as he did on August the 22nd, 1996, Tuesday at 2:55 p.m. This objection is based on his point 15 supra, which I just read to you. Cablevision Satellite Light produced no exhibits. Everything claimed was hearsay. Franklin had the evidence. He had the checks that had been deposited in the Cablevision Compensation Fund. He had the canceled checks. Cablevision Satellite would be smart, which they have never been, yet to consider the loss of reputation and bad publicity much more costly than the $350 they absconded with April the 19th, 96. Glendora will certainly expose the dastardly deed on her TV program, that is to you, who are very powerful, on 11 cable systems in Long Island, Westchester, Manhattan, and Rockland, Northern Jersey. She will tell Martinelli, that's the newspaper, weekly newspapers in Westchester. She will tell the New York Post, the Daily News, Gannett, and Newsday. The public has a right to know. She will tell multi-channel news, David versus Goliath, Cablevision bilks the little person again, and more. And at the annual meeting of shareholders in June 1997, she would tell Charles Dolan and the board of directors and her fellow shareholders about it, as she speaks at every annual meeting. If this court does not award Franklin his $350 plus statutory 9% interest, plus fee, plus travel, as the Blue Small Claims booklet says, Franklin will appeal to the Judge DePaula Court, appellate term Mineola, 9th and 10th Judicial Districts. This will be an appeal that rip-off court stenographer fees cannot preclude because, thanks to the advanced and sensible modus operandi of Judge Dickinson in Yonkers, there was no court stenographer, and the proceedings will be reported by the judge. We have been before Judge DePaulo many times, and he is keen on substantial justice. The Judge Dickinson Court is to be thanked for giving Glendora not a party to the action, but the ultimate cause of the action, an opportunity to be heard. Franklin pleads that the Judge Dickinson Court remember his plea. They don't get paid before they do it. Franklin goes to court to stand up for his substantive justice and gets ripped off by the parking machine out front. He put in $1.25, 75 cents, and got no receipts. Then, while waiting to be called to conference, he went out and put in $1.25, another $1.25. The machine robbed him again and gave him no receipt. This is $3.25, and the entry into court fee for small claims in the state of New York is only $5.86. And we got ripped off $3.25 for parking. Franklin had a witness at the trial, and David Light did not. If this matter does go to the Judge DePaula Court, a victory in the Yonkers Court will certainly be Pyrrhic. Franklin takes exception to Judge Dickinson's ruling. That's why God made lawyers. God did not make lawyers. The devil made lawyers. This whole litigation, Glendora versus Cablevision, is a record of the same. Plaintiff claimant appreciates Judge Dickinson's affording him an opportunity. One, Mr. Light put in writing his argument, and two, Franklin having a rebuttal. It is clearly a case where Cablevision's arrogance and vengeance got the better part of them, just as on November the 12th, 1993, their ignorance of the public access laws got the better of them, and they ended up defeated in the Silverman Court, and in the Second Circuit, and in the United States Court of Appeals, and in the Bryant Court. The only way they could win was to steal $1,000 victory cost, $95 for an audio tape, and $350. Plaintiff claimant appreciates Judge Dickerson's affording him an opportunity. 1, Mr. Light put in writing his argument, and 2, Franklin having a rebuttal. It is clearly a case where Cablevision's arrogance and vengeance got the better part of them, just as on November the 12th, 1993, their ignorance of the public access laws got the better of them, and they ended up defeated in the Silverman Court, and in the Second Circuit, and in the United States Court of Appeals, and in the Bryant Court. The only way they could win was to steal $1,000 victory cost, $95 for an audio tape, and $350 subpoena money. I remind you again that these people are billionaires. Even though Franklin lives in White Plains and the action could have been brought there, the Yonkers Small Claims Court is much faster to get a court date and much faster to litigate when you get before the judge. White Plains Small Claims takes over a year, but Yonkers is not as fast as it used to be. Our last case in Yonkers Small Claims was before Judge Noka. We won. It was appealed by the defendant. We won in the appellate term. We know we are right. Small Claims Court is substantive law, common law. Common law says you don't deprive a person of his property. That is, you don't steal. Thou shalt not steal is a commandment God handed down to Moses, and this court has a sign behind Judge Dickerson's head that says, "In God we trust." We will not sell our souls the way defendants Satterley and Light did and do. Let's point out that Cablevision subpoenas were not quashed. In addition to not being the whole truth and nothing but the truth, is a red herring. It is a non-issue. Cablevision's lawyer, Robert Callaghy, knew the trial was stayed February the 28th, 1996, knew that Dolan Tata et al. Did not have to give up a day, $40 by Rule 45, Federal Rules of Civil Procedure, and knew that Dolan Tata et al. Did not have to travel $30 Long Island to White Plains equals $70 times 5 people equals $350, and certainly knew the checks should not be returned, and certainly knew the checks should not be deposited in the bank, let alone in the compensation fund, quote, unquote. Franklin reproduces the transcript of this part of the February 28, 1996 conference when Glendora's trial was stayed. Judge Bryant, now as far as these subpoenas are concerned, we will just have to deal with them when the day comes because I don't have enough information really to be able to dispose of it one way or another. Bunshaft, who is a county attorney, an assistant county attorney for the county of Nassau, said, "Shall I at this time, Your Honor, complete my comments as regards Mr. Pick and Mr. Patterson, just so it's on the record for the court?" Bryant, "I don't think it's necessary." Bunshaft, "Yes, sir, Your Honor." He's so obsequious, you know. He cleans up the floor, you know, with his bowing. Bryant, "Because hopefully she is going to go back to Justice Silverman and the whole thing will be resolved." Bunshaft, "Yes, Your Honor." Bryant, "Maybe she won't." Talking about me, Glendora. Bunshaft, "Will we be notified when this case?" Bryant, "I am vacating these particular subpoenas without prejudice. If the case is re-noticed for trial in this court, she can issue a subpoena if so advised." Mr. Bunshaft, "Thank you, Your Honor." Glendora to Judge Bryant, "This is both for Nassau and for Cablevision?" These other subpoenas were for Thomas Galata and for James Picken. Bryant, "No, there is no problem with Cablevision. That motion never was even presented to me." Glendora, "That's right, it wasn't." Bryant, "It's floating around here somewhere, but I don't remember signing any order." Glendora, "That's right, you didn't." Bryant, "Let me find out about that." And then Callaghy, the lawyer for Satterley, Stevens, Burke, and Burke, and for Cablevision, said, "I have one that was signed." Glendora, "Well, I don't." Bryant, "Hand it to the clerk, because it was never returned to us with proof of service. It's supposed to come back, you know, with proof of service. You have to tell a Park Avenue lawyer that." Glendora, "Your Honor, when will I have a copy of your decision today?" Meaning signing, staying the trial. "I never got a copy of the signed copy. I never got a copy." Bryant, "That's denied as moot because there is not going to be any trial on March 4th. Glendora, "When will we get a copy of your decision today?" Bryant, "What?" Glendora, "I want a copy of your decision today in order," and his decision was to stay the trial. how can I file it without an order? Bryant, file a notice of appeal. Glendora, not without an order. You are not going to give me a copy? You are not going to give me? Bryant, it's a clerk's order. It's a one-page thing the clerk will give you. You can get a copy from the clerk's office. Glendora, when could we have a copy of your decision today? Bryant, you will have to order it from the court reporter. Glendora, you are not going to send me anything in writing? Bryant, no. Glendora, you are going to make me pay $400 for the minutes? Bryant, no, I'm going to make you go back to Justice Silverman. Glendora asks when she will get the clerk order. When, Your Honor? Bryant, today. Glendora, today. Bryant, court will be in recess. Glendora, thank you, Judge Bryant. And here's his one-page order he was talking about. It's the worst-looking thing. I should think a judge would have a little more pride. Look at this. This is a mess. Look at it. This is one-page order, and that, parenthetically, has been appealed, is down at the United States Court of Appeals, Second Circuit, waiting for an oral argument. It's fully submitted. Appellant's brief, Cablevision's anemic, appellee's brief, and my appellant's reply brief. So we're just waiting for an oral argument on that. And my argument is that Judge Bryant did not exercise judicial-making authority, decision-making authority. Now, Glendora, going back to Judge Dickerson in the Yonkers Small Claims Court, Glendora says, Franklin says, it is more important in this small claims action that the money was taken without appearances or travel than emphasizing the non-issue of whether the subpoenas were quashed. The function of small claims is to get substantial justice quickly. That a monopolistic corporation takes $350 from a 77-year-old man on pension and Social Security without fulfilling the purpose for which the money was paid is not, quote, substantial justice, unquote. Senior citizen, this monopoly, it is not right. This monopoly has made senior citizen Glendora poor also in form pauperous, with court fees, rip-off stenographer's fees, postage, printing, legal papers for 2 years and 8 months. The monopolistic corporation, Cablevision, instead of the senior citizen, gets the interest on the $350 for an unknown period of waiting. Now this is unjust. Again, Mr. Light was wrong to cite case law. The matter is being adjudicated on substantive law. All this court has to know from the Judge Bryant Court, the United States District Court, Southern District, New York, White Plains, is that the trial was stayed. Defendants did not have to spend $40 for the day, nor travel $30 to Westchester. The trial was stayed. Wherefore, Franklin F. Buell pleads that this court award him the $350 stolen from him, payable by cash or money order within 30 days, along with the cost of this action, $100, and any further indifferent relief that is just and fair. Dated White Plains, New York, August the 23rd, 1996, Franklin F. Buell. Subscribed and sworn to before me this 23rd day of August, Drew Murphy. Now that paper was handed in personally. It was served on David Light. The affidavit of service is here somewhere. It was served on David Light by United States Mail, first class, from White Plains to Manhattan. And it was handed in personally to the small claims clerk for Judge Dickerson that day, Mr. Steve. On Monday, August the 26th, Mr. Light's letter was received. It said nothing different from what he had said in court, which I've reported to you, and it just included more cases. And that is absolutely wrong. This is small claims court. Substantive law, not statutory law, and not case law. On Tuesday, along the northern state, and 295 and the Grand Concourse and 695 and the Fogs Neck Bridge and the Hutchinson River Parkway and the Cross County, Westchester Cross County, and the Bronx River Parkway, I wrote the refutation to Mr. Light's letter and presented the case and refuted every word of Mr. Light and all of the case law. That was served on Mr. Light yesterday, Wednesday, August the 28th, and it was taken to the court, personally submitted to a New York State court officer who said he would give it to Steve, who was sitting right there, and would give it to Judge Dickerson, who was sitting next to Steve, because Judge Dickerson was in small claims court again yesterday, Thursday, and he will be again today, Friday. Tomorrow, Friday, excuse me. Today's Thursday. And so that's what you call now. Yonkers Small Claims Court is a lot smarter than a whole lot of other courts. They take the litigants into a side room and they say, what's your case? And then they say to the other side, what are you going to do about it? And then if there's an agreement and a settlement, good. If there isn't, Judge Dickinson says immediately, then we'll go to trial. And he says to Franklin, raise your right hand. Great. Doesn't even go out into the courtroom. Saves all this time. So that's a good way to operate. Whereas we've been in the federal court and the state court for 2 years, 8 months, trying to bring these Cablevision, Dolan, Tata, Quinn, lawbreakers, liars, and cover-uppers to justice. 2 years and 8 months. There is the refutation of David Light's letter. Plaintiff Buell refutes letter of August 23, 1997 by David Light, received August 26. This one is very brief. I am not going to read it to you. It's only 12 pages. But I am going to show you this. This is quite interesting. Now that law I was telling you about, Title 47 of the United States Code, Section 531E, here it is. There's the statement of the law. Right here. Can you see that? Okay, that's the statement of the law. And then this is from the United States Code annotated, which not only states the law, but it gives you cases. Now you see, under this law, there are only 4 cases. In other words, since this was made law in 1984, there have only been 4 cases before the courts on this law, on this statute, federal law. Guess what those 4 cases are? Okay. Let me go back here to the desk and get my glasses, and I'll read them to you. Just 4 cases. Number 1, Glendora versus Kofall, Cablevision Systems, Dolan, Tata, Quinn, et al. Number 2, Glendora versus Cablevision Systems Corporation, Southern District of New York. Number 3, Glendora versus Dolan, Southern District of New York. Number 4 citation, Glendora versus Cablevision Systems Corporation, Southern District of New York. That means in the whole United States, since 1984 to 1996, 12 years, there have only been 4 citations under this law, and they are all Glendora versus Cablevision, Dolan, Tata, Quinn, et al. Now you see, folks, that's what you call breaking. That's what you call making law. What they did is what you call breaking law. But what I did was what you call making law. And I'm a pro se, and I never went to law school, and I never would, and I would never be a lawyer, and I would never be a judge. I cannot think of a worse existence in this whole world than being a lawyer or a judge and selling your soul. I was just standing up for my right as an American for free speech. And I won, and it made law. What else is there to report to you on the law-breaking of Charles Dolan, John Tata, William Quinn et al., and of their lying about the same, and of their covering up about the same? Well, there is the Tuesday at 6:30 a.m., Franklin and Glendora started preparing, dressing, packing, and loading the Lincoln to go down the Mamaroneck Avenue, the Hutchison River, I-95, 695, the Fogg's Neck Bridge, 295, the Grand Central Parkway, Northern State, Willis Avenue to Mineola. And there we went to the Nassau County Supreme Court, State of New York. We had no time to go to the Board of Elections. And then we went to Hicksville and we edited A Chat with Glendora with Thomas Galena. And Thomas was, with Patrick Galena. And Pat was very good. He showed Glendora how to use the Chiron to do the character generator, the graphics that you see on the screen. And Glendora knows how to hook up her 8mm camcorder, which feeds the beautiful new Sony recorder decks that Cablevision Hicksville has, how to tie that into that system, and how to tie in the music. Tie in the video, tie in the audio, and tie in the music. The audio would be the voice. Tie in the video, the voice, and the music. And then, this is a great advance, Mr. Galena took the video and audio out of the 3/4-inch recorder and fed it into Glendora's second 8mm camcorder, and then Glendora thereby got an archive. Isn't that nice? And now, when I go back Tuesday, the day after Labor Day, we hope to come out of the Sony 3/4-inch recorder and feed it into a VHS. And simultaneous, we'll get a 3/4-inch master, we'll get a VHS dub, and we'll get an 8mm archive dub. From Hicksville, we went to Woodbury, to One Media Crossway, and we handed in the log. Every week there's a Cablevision log, and I must read you their damages, the hours and the money they have cost us with their law-breaking, lying, and cover-up. So we hand in a log like this every week to Mr. Polinsky. So we did that at 320 Media Crossways. Then we went to the town of Oyster Bay, and you saw the interview with Mr. Louis Iovoli, who is a supervisor of the town of Oyster Bay and who is going to run for county executive against Thomas Galata. From there we went to Huntington, to the Huntington Library, which I love, and we looked up in the computer Cablevision and the lawsuits that have been brought against Cablevision. And we found there the Newsday story of October 1994, Gadfly swats cable giant. That was written by Sylvia Adcock. We looked at the computer and other Newsday stories about Cablevision. We took out a nice book. Last week it was Margaret Thatcher. This week Franklin took out a baseball biography. From there we went and joined the senior citizens in Huntington, and we're looking forward to going to the beach house at Centerport. And they have wonderful newspapers, and they have a meal every noon, Monday through Friday, to 1:15 p.m. And they gave us a menu, and this is the newspaper. I'd like to have you go up there and get a copy of the Senior News newspaper for Suffolk County. Last week I read you a lot out of the Senior Citizen book for Nassau County. They have all kinds of activities. The card players tried to hook us in to play cards, and they were really aggressive about it, these senior citizens, to have us sit down and play the cards. This is my second Cablevision investigations book. That's volume 2. And here is volume 1. This is my old commercial integration book when I had commercials on the NBC television network. And in here are the statistics that we have got from the Board of Elections, Nassau County. And many people have joined this movement. Richard Einhorn, Phil Goldstein, Elizabeth Chamberlain. And the movement, of course, is that cable operators are breaking the law and are not giving you citizens your public access rights. For one thing, on the Woodbury system, which is all of Nassau County, Huntington, Islip, and Babylon, we are not getting our designated public access channel. People want to have their programs on public access, and there isn't enough room because we are sharing a channel with Telecare. I love that Telecare thing. I like the whole concept of it. And I've been trying to get Father Tom Hartman to call me and either give me over the telephone and on audio tape a history of Telecare channel or to send it to me in writing. But I have got no response as of yet after 6 requests. What else is there to report upon? Oh yeah, the stats. Okay, that's over here in a different log. Isn't it? Or is it on page 1 for the log of the week of August 26th? I wish you could see the kitten. The kitten is sound asleep because of the 600 watt light. Doesn't bother her a bit. She's right back to sleep. Well, folks, I can't find them. So I'll have to do it from, I'll have to build it up for you. We have spent 3,211 3/4 hours on the law breaking of Charles Dolan, Cablevision Systems Corporation, John Tata, William Quinn, et al. Over a period of 2 months, 2 years and 8 months. 2 years and 8 months. Now, if you take 3,211 3/4 hours and you multiply it by $250 an hour, which is what these monopolistic and antitrust lawyers get together and collude and rip off the public for, that comes out to over $800,000 worth of legal work we have done on the Cablevision law-breaking, lying, and covering up. We have spent $6,746.75 on postage, print, rip-off court stenographer fees, and court fees, bringing these people to justice. There are, I believe, 44 volumes of bad record of these people. There are 13,070 pages of bad record of these people. 4 file drawers full. There have been 278 TV reports, all bad about them. Half an hour each on television. And those are the stats. That's what the law-breaking, lying, and covering up of Cablevision has cost us. I want to get in here. This is the second part of the article by my amici curiae, Brian Grafman and Robert Perry in the New York Law Journal. This article was in the New York Law Journal, the second part and final part, on Friday. And here's a picture of Mr. Perry. He's a professor of law at New York University, and Mr. Grafman, who is in private practice. And they are specialists on free speech and public access. Mr. Perry's been at this for 15 years, and in this article is about the Denver decision by the United States Supreme Court, which is a part of television I really don't want any part of. Its indecency and obscenity. I really don't want any part of that. But it hinges onto me because of free speech. My speech is protected by the Constitution of the United States. Okay, and I sent that to over 6 judges, Perry and Grafman. And I believe that's all there is to report to you, and that's a great relief because now we have time for jokes. And the kitty is doing her ablutions. To answer this question, what do they call a coffee break? What do they call a coffee break at the Lipton Tea Company? Do you know what a judge is? A judge is a person who keeps learning more and more about less and less until he knows everything about nothing. And what is the formula for water? Chemical formula for water. That's right, H2O. You know, what's the formula for an ice cube? H2O squared. John wants to know, why is living in California like eating granola? Well, after you finish with the fruit and the nuts, you got plenty of flakes left. Did you ever try to explain counterclockwise to a person who wears a digital watch? And the English language is further very, very interesting. Do you notice that we park in a driveway and we drive on a parkway? And if the world is getting smaller every day, why is the price of airline tickets continually increasing? Little baby cat wants to say goodbye to you. Say goodbye, honey. Let me take her over close so that you can see her. She's adorable. Remember last week she went to sleep in my hat? Cat in a hat. Yeah. Yeah. Yes. She wants to sit on my purr. Can you hear her purr? Oh, she purrs all the time. She just wants to be cuddled in the arms. We're going to say our Bible passage, which I think is Mark 11, verse 12. So then, we all must stand, give account, and that's it. So then we all must give account of ourselves before God. This is a chat with Glendora. Protect your rights. There's somebody out there every minute of the day trying to take your money, trying to take your rights, but you stand up for them, and don't you let them get away with it. Also, I'd like to call your attention to the Americans for Legal Reform, and call the number that you see on the screen, because they are fighting bad lawyers. They went out and they demonstrated in this hot-pog in the courts out there and told the lawyers that they weren't getting away with it, that everybody realizes what the lawyers is doing. And one of them, a member of the Americans for Legal Reform, says that lawyers now have a public image lower than that of a used car salesman. Americans for Legal Reform. That lawyers right now, an issue that we're trying to get through is that lawyers must have open hearings, and when a person makes a grievance against a lawyer, it must go before the public immediately. Immediately it must go before the public, and it mustn't be hidden the way it has been for years. Also, you have the fact where lawyers are 1% of the population, and yet they're making all of the laws and getting all of the advantages for themselves. You don't like lawyers either, Kitty? What's been your experience with lawyers? So goodbye, folks, and keep your courage flaming. Amos B. Hofstadter and Nair and Schleier and DeLorme and Hawthorne and Ritter and Continental Cablevision Incorporated, Melissa Cooper, Diane Rainey, Greg Sanders, Douglas Guthrie, and American Cablevision Cable Systems of New York Incorporated. First of all, here are your jokes. Bill says that more people would be interested in the Electoral College if they had a football team. And there are 5 billion ballpoint pens manufactured in the United States in a year. How come there's never one near the phone when you want to take a message? And if it's such a small world, how come it costs so much to run it? And did you hear about the Czechoslovakian trampoline team? They're called the Bouncing Czechs. And psychiatrists use such big words like, I see you are suffering from cashew maraschino syndrome. And what does that mean? It means you're nutty as a fruitcake. Now, here's what's going on in this, well, here's what started it. All of these defendants whose names you see upon the screen broke the laws. They broke the law, first come, first serve. They took 29 public access producers who had been on the TV channel for years. All of a sudden, they stopped cable casting their programs every other week. And that broke several laws, state laws and federal laws. And Glendora sued them for $298 million. Instead of facing up to what they did, they're not nice people, so they lied and they covered up. They are greedy cable operators, arrogant, ignorant, and monopolistic. So where does that stand now? Glendora brought suit against them 1 year ago in the United States District Court, Southern District of New York. We do not have adept judges. We do not have judges who are interested in justice. All of these judges do is just waste time and protect the lawbreakers. So they made a motion for summary judgment, and a summary judgment can be granted only if it's on the basis of law and if there's no dispute of facts. Well, there's disputes of facts, hundreds of facts. And laws, a judge is supposed to decide on the law. None of them do that very well, and the jury decides upon the facts. And so there is a dispute of facts, hundreds of facts, and so a jury has to decide this. That's in one court. That's the United States District Court, and this is a little kitten that we rescued. Why don't you name this kitten? What name do you want to give this little kitten? We call her BW for short, for black and white. So that is before Judge Lisa Margaret Smith, who is a magistrate. And then the bad work of Judge Barrington D. Parker, Jr., of not granting us a preliminary injunction, which it should have been done because Judge Parker is guilty of breaking the law just the way these defendants are. And so that bad decision, rotten decision, is being appealed in the United States Court of Appeals. And where does that stand? It is fully submitted. The appellant's brief, the appellee's brief of lies, and the appellant's reply brief have all been submitted. We are waiting for an oral argument date. So it's in two courts, and we're waiting for a decision on the summary judgment. Now, there's another matter, is that they have lied and covered up about the insurance agreement, and they will not tell who their insurance company is. So we have gone to the town and the village of Ossining to try to get a copy of that insurance agreement and also a copy of the bond that Continental has to put up for the town. And now you get stonewalled there. And here is Franklin Buell to tell you about his trip to the town hall of Ossining yesterday, and the rest of it about the village hall. And here is Franklin Buell.
We went yesterday, August 28th, to the Ossining Town Hall about this matter of the insurance agreement and the bond that Continental is to furnish to all franchise areas. Glendora and I had been there earlier, and a few days ago Glendora had quite a long conversation with the town supervisor, and I was going in to follow up on that. The franchise says that the cable company will provide a certificate of insurance with the town, which should be kept on file by the town clerk, and also the details on the bond that the cable company supplies to the franchise area. I went into the supervisor's office on the 3rd floor of the town hall. Mrs. Monahan was there. She's the secretary. Glendora and I had talked with her a few months ago, and